But everyone around him is happy for any pretext to unleash violence on American cities where a lot of Democrats live. So the next day, Hegseth puts out this memo that says 200 members of the Oregon National Guard will be called into federal service effective immediately for a period of 60 days.
Yeah, and the asserted legal justification here was that same generic June 7th memo. But even more so than in Los Angeles, it is clear that none of the preconditions for Section 12406 were met in Portland.
Welcome to Law and Chaos, where the government is shut down, ICE is laying siege to cities, and SCOTUS is borked. But on the plus side, Alex Jones is about to get what's coming to him, and Law and Chaos is breaking news about our FOIA suit against the DOJ. We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you?
I mean, it's wild. It's wild.
Did you at least have a good weekend?
I did have a really lovely, lovely weekend. So thank you for asking. And you?
I also had a very nice weekend, but I know I'm with you. I am super excited to break some news here. Why don't you start us off?
All right, so let's start with our exciting update on our FOIA lawsuit. As we've said before, we have sued the Department of Justice and asked them to produce one single document.
Yeah, cough it up, Pam.
Indeed, and also, as we said in our post yesterday, we know you're lying, Pam.
True, but I think you're going to have to narrow that one down just a little bit, Liz.
Okay, so for background, the DOJ filed a judicial ethics complaint in July against Chief Judge James Boasberg of the U.S. District Court for the District of Columbia. That complaint, which was hand-delivered to Chief Judge Sri Srinivasan of the D.C. Circuit, alleged that Judge Boasberg attempted to intimidate Chief Justice John Roberts at the March meeting of the Judicial Conference. That's where judges from each district convene twice a year to hash out rules for administering the federal judiciary. There was not fisticuffs. I know what you're thinking, like old man fight. But no, the story the DOJ tells is that Boasberg, quote, attempted to improperly influence Chief Justice Roberts and roughly 24 other federal judges by straying from the traditional topics to express his belief that the Trump administration would, quote, disregard the rulings of federal courts and trigger a constitutional crisis.
And if Judge Boasberg said that, that is exactly what the Trump administration absolutely 100% did. And in fact, did in front of Judge Boasberg just a couple of days after the conference on March 15th in the JGG immigration case. That was when Drew Ensign got up and said, I don't know if any planes are taking off, Your Honor, when he absolutely did know. And then 2 more planes took off after Judge Boasberg said, turn those planes around.
Yeah, and look, I don't think it's possible to talk about this story without situating it in the right-wing news cycle, because this story was first reported by Margot Cleveland, this weirdo at The Federalist, who hyperventilated about it on July 16th. Yeah, no, okay. She's a very specific kind of weirdo, but I'm not going to get into that. She hyperventilated about this story on July 16th. She said that she had a memo with minutes from that judicial conference meeting that proved that Judge Boasberg and his colleagues on the trial court in D.C. are biased against a litigant before them, i.e. Donald Trump, the perpetual defendant in all of these, immigration cases and such. She claimed to be shocked and outraged at the suggestion that judges would worry about defiance by the Trump administration because, as everyone knows, the Trump DOJ would never, not ever, defy a court order.
Indeed, how dare you even suggest such a thing?
Right. So notably, Cleveland did not publish that memo or even an excerpt. So the story, after she publishes, makes the rounds in conservative media. Mm-hmm. John Yoo tries to waterboard it into existence on Fox. And then a week later, the DOJ filed this supposed judicial ethics complaint against Judge Boasberg with the exact same quotes and allegations as Cleveland had written in her post. And as proof, the DOJ dropped to a footnote that said, see attachment A at 16. And then Pam Bondi and the rest of the Howler monkeys tweeted about it and said they're not going to stand for this assault on the integrity of the judiciary.
Yeah, assault on the integrity of the judiciary is the job of the president, who, shit posts about the judiciary every single day. Or maybe it's the job of Stephen Miller, who just called for violence against what he termed insurrectionist judges, or...
Yeah, so many, right? But notably, the DOJ did not attach this memo to the copy of the complaint that they distributed to reporters. There was no attachment A on the copies of this letter to Judge Srinivasan, which circulated in D.C.
Right. And I think we should acknowledge that we do not know for certain who distributed this complaint to reporters. I guess it's possible it was not the Department of Justice.
Well, fair. Although the complaint published by Politico and Courthouse News was unsigned, so this letter had Chad Meisel's signature line, but no signature. Presumably, if it came out the other end, it would have had Chad Meisel's John Hancock on it. But whatever. Right. Bondi was the one putting all this shit on Maine and trying to make political hay out of it. She's the one who made this complaint a public issue. If she'd kept her mouth shut, as she absolutely should have, no one would have known about it. And
not us.
Now we're here to break some news on our show because we have learned from a source familiar with the matter that the Justice Department did not give a copy of this memo to Judge Srinivasan either. Attachment A does not exist. And in fact, Judge Srinivasan tried to get a copy of Attachment A from DOJ, and he got nothing.
Yeah. So in support of their claims that Judge Boasberg violated the canons of judicial ethics by talking smack about Trump, the Department of Justice has supplied exactly zero evidence to the U.S. Circuit Court of Appeals for the D.C. Circuit, to Judge Srinivasan. They've got that evidence. It's Attachment A. May the court see it? No.
Okay. So as we said, we filed this FOIA request back in July to get the attachment.
Right. It is clearly an agency record subject to the Freedom of Information Act. It was generated outside of the Department of Justice. It was then sent, or apparently not sent, to the judiciary. But irrespective of whether that copy ever arrived at the Circuit Court for D.C., it has to be disclosed. So we filed our request, and we asked for it to be expedited. And the Justice Department's Office of Information Policy said no to expediting. And not only no, they said they had to put us on the complex track.
Right, so they'll get to that never.
Yeah, this is so ridiculous on a bunch of levels. First, they said it didn't require expediting because this isn't a matter of pressing public concern.
Pam Bondi herself tweeted it out. I mean, come on.
Yeah, and the justification for putting us on the complex track is that the search apparently involves, quote, a search for and collection of records from field offices or other separate offices, and thus your client's request, that's us, Law and Chaos Pod, your client's request falls within unusual circumstances, which, no, it does not. This document was on Pam Bondi's desk 10 minutes ago. It is one record. We did not ask for every time the Department of Justice used the word Portland in an email. We said, give us this one document that you received from an outside source and forwarded, or at least referenced, in communications with another branch of government. This is the definition of the least complex request you could ask the government to do. We only want one thing.
Right. So we filed our motion for summary judgment, which the government will respond to once the shutdown is over. I assume that's why the government closed. They're just that scared to give this thing to us.
Oh, is that why?
I mean, maybe not, but I do think the government's reluctance to give this to us and also to Judge Srinivasan indicates that either they don't have it and they just copied Margot Cleveland's work, or it doesn't back up their case at all. Whatever it says, if we could see it in context, would make it look like they were full of shit. At a minimum, their refusal to disclose it suggests that they are filing judicial complaints purely as a publicity mechanism.
Yeah, this judicial complaint could have been a press release. And functionally, it was, since they've failed to disclose the evidence.
Yeah, undermining public confidence in the integrity of the judiciary by accusing Judge Boasberg of undermining the integrity of the judiciary is That's some bullshit right there.
I am very anxious to see this document because one of the things that Margot Cleveland said in her piece, I'm going to quote this, was that Chief Justice Roberts expressed hope that, meaning disregarding judicial orders, would not happen, and in turn, no constitutional crisis would materialize, according to the memorandum. The summary of the working breakfast added that Chief Justice Roberts noted that, quote, his interactions with the president have been civil and respectful, such as the president thanking him at the State of the Union address for administering the oath. And,
oh, please.
Yeah, my confidence in Chief Justice Roberts' integrity is pretty low, but that moment at the State of the Union where Trump said, thanks for what you've done for us, we won't forget, and Justice Barrett visibly rolled her eyes so hard she almost passed out, that was not a good look for the Supreme Court. Literally, no one believes that interaction was an expression of gratitude for administering the oath of office. Come on, be for real. So, either there's some missing context here, or Roberts is even more out of touch than we thought.
I mean, probably both, to be honest. But, I mean, that struck me as ridiculous. That was a moment of ignominy for the court. Yeah. And it seems almost impossible to me that Roberts could have been like, well, obviously Trump won't defy court orders because he was so nice to me at the State of the Union. Like, I mean, I don't think so. Yeah. But... Okay, we will keep you posted on that. We are super excited to get a response should the courts ever open back up. And we're going to actually talk about that. We'll talk a little bit about the shutdown and the effect on all of the cases that we follow when we come back from this brief ad break, unless, of course, you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case, no ad breaks for you, not today and not ever.
And we're back. Okay, Liz, the government is shut down except that ICE is still conducting raids and provoking street brawls, and Donald Trump is trying to invade Portland, Oregon and Chicago, Illinois, the way he did Los Angeles. So let's talk about the government shutdown. The proximate cause of the shutdown is because Congress failed to pass a budget bill for the 2025-2026 fiscal year. And in a deeper sense, this battle really reflects the breakdown when Democrats know that Donald Trump is trying to steal Congress's power of the purse, and Republicans are trying to let him. We have talked about all these impoundment cases where Trump just says, I'm not going to spend money in the budget bill, and then the Supreme Court lets him do it again on the shadow docket. So, in a very real sense, why should Democrats negotiate a deal if Republicans are just going to let Trump take a Sharpie to whatever they agree to?
And Republicans are just going to blame Democrats anyway. Like, we might as well stand up and stand for something because, we're still going to get the rough end of this news cycle. So, okay, on our way to talking about how this impacts the 11 million federal cases we follow on this show, here's the TLDR, because obviously we are not a policy shop, we are a law shop, but we do want to talk a little bit about this. The fiscal year ends on September 30th. As of that date, Congress was unable to pass an Appropriations Act, which is the budget, for fiscal year 2025-2026, which we are now in. And that means that as of October 1, there were no funds allocated for annual federal government programs.
Right.
That does not mean that the entire federal government disappears, right? Programs that are not funded by annual appropriations can still operate. And there are emergency funds previously allocated by Congress to keep the lights on, at least for a little while. But for the vast majority of federal government programs, the operative law is the Anti-Deficiency Act of 1884, codified at 31 U.S.C. 1341 and 42.
Right. Section 1341 says that no officer or employee of the U.S. government or the District of Columbia may make or authorize an expenditure or obligation or involve the government in a contract or obligation for the payment of money before an appropriation is made, unless otherwise authorized by law.
So in English, that means the government cannot spend money, pay employees, or even issue IOUs while the government is shut down. And Section 1342 says it can't let employees work for free either. So an officer or employee of the U.S. government or of the District of Columbia government may not accept voluntary services for either government or employee personnel services exceeding that authorized by law, except for emergencies involving the safety of human life or the protection of property. And then there's this clarifying provision that says emergencies do not include ongoing regular functions of government, the suspension of which would not imminently threaten the safety of human life or the protection of property.
Right. So to put those two provisions of the Anti-Deficiency Act together, without a budget or other congressional allocation, the federal government can't pay anyone to work for it, can't promise to pay anyone in the future when a budget does get passed, and can't let anyone work for it for free unless it falls into one of those exemptions, which is why the vast majority of federal government employees were furloughed starting October 1. And I should add parenthetically that the Anti-Deficiency Act also protects those employees. Section 1342 also says that when the government is funded, each employee furloughed as a result of a covered lapse in appropriations shall be paid for the period of the lapse in appropriations at the earliest date possible after the lapse in appropriations ends. Relevant to our beat, one of the government agencies that is paid out of the annual budget is the Department of Justice. So there's a question about whether the DOJ falls into those authorized by law or necessary to protect human life and property exceptions. And the answer is sort of.
Yeah. So prior to the shutdown, the Justice Department formulated a contingency plan. We can link to it in the show notes. It says, with respect to litigation, the department's plan assumes that the judicial branch will continue to operate, though possibly at a reduced level through the lapse. Therefore, criminal litigation will continue without interruption as an activity essential to the safety of human life and the protection of property. And just to kind of flesh that out, the judiciary has said that it can operate basically through the middle of October, maybe October 13th or a little bit after that. So this is a short shutdown, right? This says we'll be fine if the shutdown is basically less than 2 weeks. If it's more than 2 weeks, we're screwed.
And in addition to the judiciary itself, there's also an unstated reason underlying this memorandum as to why the government's ability to prosecute criminal cases has to continue uninterrupted through any budget showdown, and that is the Sixth Amendment. The Sixth Amendment says, in relevant part, that if you are charged with a federal crime, you have the right to a speedy trial. And what's a speedy trial? That is implemented by the Speedy Trial Act of 1974, which is codified at 18 U.S.C. Section 3161. That says that the government must bring you to trial within 70 days after the issuance of an indictment or criminal complaint, unless there are agreed upon pauses in that 70-day clock. And there are no Sixth Amendment exceptions for, our government is broken and prosecutors aren't getting paid.
Right. But a lot of what we follow here are lawsuits against the government, and that is civil litigation. So here's what the plan says about that. Civil litigation will be curtailed or postponed to the extent that this can be done without compromising to a significant degree the safety of human life or the protection of property. Litigators will approach the courts and request that active cases be postponed until funding is available. If a court denies such a request and orders a case to continue, the government will comply with the court's order, which would constitute express legal authorization for the activity to continue. Mm-hmm. And so, on October 1, when the government shut down, the Justice Department moved to stay more or less every civil case at once. And most courts granted those motions. A lot of them said, okay, as soon as the government comes back, your response will be due in 10 days, whatever pending motions you have. But some judges did not agree, including Judge Gia Cobb, who's presiding over a challenge to the deployment of state National Guard units in D.C. She cited the second part of that contingency plan and said, okay, here's that court order that operates as an authorization, so no stay for you.
Right. The DOJ's own contingency plan says if a court tells us we have to keep going, that is express legal authorization. Second, that plan also explicitly exempts litigation over temporary restraining orders and preliminary injunctions. And third, We're talking about cases where the plaintiffs allege that the government is doing patently illegal, unconstitutional stuff. It would be ridiculous to say that the absence of a budget provides carte blanche for the Trump administration to break the law, and we're powerless to even challenge it. So, for example, in Doe versus Newsom, which is one of the immigration cases, the plaintiffs opposed the stay. They cited both that contingency plan relied upon by Judge Cobb and also the fundamental unfairness of letting immigration enforcement proceed unaffected by the lapse in appropriations, which is happening, right? On October 1st, the U.S. Immigrations and Customs Enforcement, ICE, right, made clear on social media that its operations would, quote, remain unchanged. So if ICE is continuing to round people up, then plaintiffs still have the right to go into court and challenge what ICE is doing.
Okay, so TLDR, we're not shutting down because our cases are not shutting down either. There will still be litigation ongoing. But we do appreciate that a lot of people who listen to us work for the federal government are in a rotten situation right now because they're not getting paid. And so all love, we hope that this ends. We obviously support Democrats standing up and not getting rolled, but we appreciate that there is a human cost. So
yeah.
Okay, a couple of other important news stories we're following today. The first is that the Supreme Court has found the one person in federal government they will not let Donald Trump summarily fire. And it just so happens to be the person whose termination could affect their retirement accounts.
That's probably a coincidence.
Oh, for sure. So a week before SCOTUS functionally overruled Humphrey's executor on the shadow docket. That was the 1935 case where the court said that Roosevelt could not fire the chair of the FTC, the Federal Trade Commission, in defiance of the law that said the FTC chair could only be fired for cause. Donald Trump came into office, immediately fired his FTC chair, Rebecca Slaughter, and the 6 conservative justices said, go for it.
Right. But they've been making weird noises about the Federal Reserve being a different class of animals somehow. They're still workshopping that Fed exception. Anyway, the Trump administration filed for emergency relief, asking the Supreme Court to stay the district court's order keeping Lisa Cook on the job, which would have run contrary to both the trial judge and the D.C. Circuit, and would have effectively allowed the administration to fire Lisa Cook, a member of the Federal Reserve Board of Governors. And 10 minutes after the Slaughter order came down saying, oh yeah, fire Federal Trade Commissioner Rebecca Slaughter, that's just fine, the Supreme Court rejected the request to stay the lower court's order keeping Lisa Cook on the job and instead set the case for oral argument in January. So Lisa Cook gets to stay on the job on the Federal Reserve Board of Governors at least for another couple of months.
Well, I suspect if they are going to hear it in January, they intend to leave her there. Probably in, look, the Supreme Court doesn't issue orders the next day. Generally, it would be, if January, then, until they disposed of the case, maybe within 3 months. But I appreciate that they don't want to break every single goddamn thing all at once. And speaking of not breaking shit, the First Circuit joins the Ninth in blocking Trump's effort to do away with birthright citizenship. Remember, the Supreme Court used the issue of birthright citizenship to discover the heretofore unobserved illegality of nationwide injunctions, because there were all of these courts that issued nationwide injunctions and said, that's completely unconstitutional, so it's unconstitutional nationwide. To be clear, the Supreme Court said nationwide injunctions were highly disfavored and only allowed if nothing else could provide the plaintiffs with full relief. They didn't know this during all of those nationwide injunctions against Biden trying to, deliver on his campaign promises, but here we are. So previously, if something was unconstitutional in Maine, it was presumed to be unconstitutional in Montana, and a judge in either state could issue that nationwide injunction. No more. So that meant that all of those rulings where courts had said, no, you can't, undo birthright citizenship by presidential fiat, you racist goon, and issued nationwide injunctions, had to be reconsidered. And every one of those reconsiderations has come to the same conclusion that nationwide injunctions are really the only remedy that will give adequate relief to the plaintiffs. And you really don't have to think about that one very hard, right? If you are born in Maine to parents who are undocumented and you get a birth certificate, how do you know you're going to be able to travel to Texas and be treated like a citizen? You just don't. And look, is Maine supposed to treat a child who was born in Texas but doesn't have a social security number, like a citizen when she moves east and like enrolls in public school. Like, it's unworkable to have this patchwork.
Yeah. Liz, I'd like to read just the conclusion of this opinion to you, because the judges squarely situate this latest attempt to ban birthright citizenship in the context of so many of the most shameful, most racist chapters in our nation's history. The First Circuit says, our nation's history of efforts to restrict birthright citizenship, from Dred Scott in the decade before the Civil War to the attempted justification for the enforcement of the Chinese Exclusion Act in Wong Kim Ark, has not been a proud one. Indeed, those efforts each have been rejected, once by the people through constitutional amendment, and once by the court relying on that same amendment 3 decades later, and at a time when tensions over immigration were also high. Even the denial of citizenship to Native American tribal members no longer persists, thanks to a statute passed more than a century ago, and there's a reference to the Indian Citizenship Act of 1924. The court concludes, the lessons of history thus give us every reason to be wary of now blessing this most recent effort to break with our established tradition of recognizing birthright citizenship and to make citizenship depend on the actions of one's parents rather than, in all but the rarest of circumstances, the simple fact of being born in the United States. Nor does the text of the 14th Amendment, which countermanded our most infamous effort to break with that tradition, permit us to bless this effort any more than does the Supreme Court's interpretation of that amendment in Wong Kim Ark, the many related precedents that have followed it, or Congress's 1952 statute writing that amendment's words into the U.S. Code.
Yeah, I don't think that there's any way to say it more plainly. There is no basis for getting rid of birthright citizenship other than racism. Racism is the main product of the Trump administration. We've seen that in every single thing that they've done. The impoundment issues where they refuse to spend money, most of that is because they want to deprive minorities and disfavored populations of federal funds. We've seen that with these immigration actions, which are so clearly racist. We're going to talk about those in a minute when we come back. And birthright citizenship. There's no reason to do this other than gross racism.
Agreed.
Okay, we will be right back to talk about those immigration decisions in just a moment. And we're back. Okay, we are recording this show a day early, and so we don't know exactly how things will have unfolded in Oregon and Illinois as you are listening to this. This is a really kinetic situation. But we can make some general comparisons about the military deployments in these 4 U.S. cities, Los Angeles, Washington, D.C., Chicago, and Portland, Oregon. Each of these military deployments or attempted military deployments is proceeding in a sort of unique posture based on the different facts and law, but they are all playing into each other, both in the ways that the government tries to position itself and in the court's responses. Although we're going to say DC has a big asterisk next to it because it's not a state, obviously.
It does, but D.C. should be a state, and that should be a primary plank of the Democratic Party going forward, no exceptions. But, as you said, Liz, the federal government has control over the District of Columbia in a way that it does not over the other 3 cities, which are situated in states. So I agree with you, we should cabin what happened there in the main. Other than to point out that because the District of Columbia is not actually the Mad Max hellscape that Donald Trump claims, there wasn't all that much for the troops that he deployed there to do, right? We were left with those vivid images of troops wearing bright orange vests over their camo uniforms while wandering around picking up trash, which is a public service, to be sure, but also a gross waste of resources.
Totally. But then, of course, Trump took credit for cleaning up D.C. He was like, there's no more murders. We solved it all. Obviously. All right.
There's more ornamental kale.
But turning to Los Angeles, on June 6th and 7th, after ICE swept in and started grabbing every brown person they could get their hands on, there were isolated protests and a couple of hours of low-level violence. That violence was immediately put down by the LAPD, which has some experience with riots. It did not rise to the level of an emergency, but it generated a ton of footage, which President Trump was able to cite in a memorandum calling up at least 2,000 National Guard personnel into federal service for 60 days or longer, supposedly to protect ICE from protesters. The asserted legal basis was 10 U.S.C. Section 12406, which allows the president to federalize a state's National Guard if one of three preconditions are met. Those are 1, an invasion or danger of invasion by a foreign nation; 2, rebellion or danger of rebellion against the authority of the government of the United States; or 3, the president is unable with regular forces to execute the laws of the United States.
And clearly none of those three preconditions were met in Los Angeles, so the state of California sued, seeking an emergency injunction. Judge Charles Breyer agreed that there was no emergency and immediately enjoined that federalization order, but he was blocked by a very conservative panel of the Ninth Circuit Court of Appeals. So the National Guard stayed under federal control, under the control of Secretary of Defense Pete Hegseth. The judges on the Ninth Circuit said that the president's determination that there is an emergency sufficient to satisfy one of those preconditions of Section 12406 is due a high level of deference, but critically, not complete deference, right? It wasn't absolutely non-justiciable. The court can review it, and importantly, a court does not have to defer to a determination that is made in obvious bad faith.
Right. So the Trump administration argues here, as it always does, that the president has absolute, unreviewable power to declare emergencies. No court can counter him, even if those declarations of emergency are based on false statements of fact. Nothing a court can do about it. That's his position. He says, we've seen this over and over. He says, we're being invaded by the Venezuelan government, using Tren de Aragua's shock troops. That's objectively not true, but he insists that courts have zero authority to review it. He wants the ability to declare alternative facts true simply by presidential fiat.
As long as we're designing the Democratic Party platform, after making D.C. a state, we need to get rid of these emergency powers. That's plank
yes.
2. Right? But okay, we're stuck with this legal framework. The Ninth Circuit said that courts have to be highly deferential, but not entirely deferential. And so the Ninth Circuit pointed to the sporadic pockets of violence in Los Angeles that were cited by the government as justification, and they concluded, well, it's not crazy to call this piddly shit an emergency that prevented the president from executing laws, and because we owe his claims so much deference, we guess this is enough to satisfy 12406. In the meantime, that original order federalizing the California National Guard expired on August 6th. So the day before, August 5th, Secretary Hegseth issued a new order federalizing 300 California National Guard troops for an additional 90 days. So they're going to stay on through November. The claimed justification for those extra 90 days was that original June 7th generic memo that you referenced, Liz. This federalization was not tied to any specific emergency under 12406. The administration's view was, we declared an emergency once, it passed muster, we don't have to declare it ever again. That can justify sending any troops anywhere for any amount of time.
And they did, in fact, talk about, they'll maybe protest in other states, so maybe we'll use these National Guard troops. We'll keep a reserve of National Guard troops deployed so that we can kind of dispatch them to go around the country. And I'm not sure that that's legal. But okay, put a pin in that because we're coming back to those troops. But that is California. Trump and his goons have had a hard-on, not to put too fine a point on it, to sick the military on blue cities forever. Wow, I'm batting 1,000 here. Anyway, they seized on a couple of hours of kids throwing rocks as justification to do it in LA. But that is not what happened in Portland. There, President Couch Potato saw some B-roll footage of the uprising in Portland 5 years ago. He thought it was real and current, and he announced on September 27th that he was directing Secretary of War Pete Hegseth to provide all necessary troops to protect war-ravaged Portland and any of our ICE facilities under siege from attack by Antifa and other domestic terrorists. Thank you for your attention to this matter. This pronouncement was made on Truth Social, obviously. Mm-hmm. And obviously, Portland is not war-ravaged, and maybe Trump is too stupid to know that. One never knows. But everyone around him is happy for any pretext to unleash violence on American cities where a lot of Democrats live. So the next day, Hegseth puts out this memo that says 200 members of the Oregon National Guard will be called into federal service effective immediately for a period of 60 days.
Yeah, and the asserted legal justification here was that same generic June 7th memo. But even more so than in Los Angeles, it is clear that none of the preconditions for Section 12406 were met in Portland. So Oregon went to federal court seeking an injunction to block the federalization of its National Guard troops. That case was first assigned to Judge Michael Simon, who is a Biden appointee. He recused himself at the government's request because his wife is a member of Congress. She publicly opposed the troop deployment. So then the case was assigned to Judge Karen Immergut, who is a very conservative Trump appointee. She worked for independent counsel Ken Starr back during the Clinton impeachment. She was the lawyer who personally deposed Monica Lewinsky. But as conservative as she is not MAGA red-pilled. She served as U.S. Attorney for Oregon. She was a state court judge. She actually, as far as we can tell, believes in the rule of law, and she bench-slapped the shit out of Donald Trump's plan to federalize Oregon's National Guard.
Yeah. So remember, we just talked about this. The Ninth Circuit said judges have to be deferential to the president's claim that the 12406 preconditions were met, but they can still evaluate the evidence. And so Judge Immergut went through everything happening outside the federal immigration facility in Portland in the past 6 months, particularly the month leading up to Trump's proclamation. And she said that the government's version of events was simply untethered to the facts. That's a quote. I actually think this passage sums it up. She said, defendants describe only 4 incidents of protesters clashing with federal officers in the month of September preceding the federalization order. The first involved protesters setting up a makeshift guillotine to intimidate federal officials. The second involved 4 people shining overpowered flashlights in the eyes of drivers. The third involved someone posting a photograph of an unmarked ICE vehicle online. And the last involved additional drivers having flashlights shown in their eyes. These incidents are inexcusable, well, maybe, but they are nowhere near the type of incidents that cannot be handled by regular law enforcement forces. They also occurred at least 2 weeks before President Trump issued his directive. More broadly, these incidents are categorically different from the violent incidents as described in Newsom 2, that's the case at the Ninth Circuit, that took place in Los Angeles when the president federalized the California National Guard on June 7th, 2025.
Yeah.
So that thin record brought Judge Immergut to the conclusion that Trump's decision was not conceived in good faith, which the Ninth Circuit said was a prerequisite for affording it any deference at all. She quoted Trump's own words about war-ravaged Portland and professional agitators who were paid a lot of money by rich people and anarchists and crazy people burning down buildings, including federal buildings. And she concluded that whatever the factual basis the president may have had for these allegations, nothing,
None.
None. Let's go with none. Nothing in the record suggests that anything like that was occurring every night or even any night outside the Portland ICE building or in the city of Portland in the days or weeks leading up to his September 27th directives. She said, in sum, the president is certainly entitled to a great level of deference in his determination that he is unable with regular forces to execute the laws of the United States, but a great level of deference is not equivalent to ignoring the facts on the ground.
Hear, hear.
Okay, we're going to take another ad break. We will be right back.
Now, as you can imagine, the Trump administration has already appealed Judge Immergut's order to the Ninth Circuit. It is not clear to us if this case will be assigned to that same bad panel as related case, right? It's a different deployment. It's a different plaintiff. I could see it going either way. But whether it goes to that same panel or not, I think Judge Immergut has done as good a job as any trial court can do of persuading that panel, hey, look, you said we owe this determination deference, but it is not unreviewable if there's any daylight, right? If deference means actually evaluating the facts, this is entirely made up. And I'm cautiously optimistic. What do you think, Liz?
Well, I think I'm optimistic, although I think it depends on the panel. But I want to highlight the ways that these two situations were different, right? Because in Los Angeles, Trump sent in ICE to be really confrontational and effectively provoked a response, right? And then the response, which was entirely predictable, was cited as justification to deploy the National Guard. Here, he didn't do that, right? I think ICE was in Portland, but it wasn't the same level of conflict. But Trump convinced himself that there was this conflict and then cited his own delusion as justification under 12406 to invoke the National Guard. And that's why you got a different response. Sort of different. Yes, Judge Breyer in California initially, enjoined the deployment of the National Guard. That was overruled. But taking into account the Ninth Circuit's decision overturning Judge Breyer, Judge Immergut was able to reach the opposite conclusion. And I think there's a strong case that the government's appeal of Judge Immergut's decision in Oregon should not go to the same panel because the facts are so very different on the ground. And this whole situation is evolving. Remember, we said that Pete Hegseth had retained some of California's National Guard troops as this kind of deploy at will around the country force. After Judge Immergut said that Oregon's National Guard troops could not be deployed, Hegseth has now said he's going to send California's troops into neighboring Oregon. Governor Tina Kotek in Oregon says she's going to challenge this. And indeed, I think I see right now, although I haven't looked at it, there's an amended complaint on the docket and another request for an emergency temporary restraining order. And Governor Gavin Newsom in California says that he also will challenge the deployment of California's National Guard troops to Oregon.
Yeah, a couple of things here. Number one, Governor Newsom also filed an amicus brief in that first challenge and basically said, hey, California went through this already and it is clear that this is pretextual. So Governor Newsom is active in the Oregon case and has been involved as an amicus. Point number two, the legal basis here, I expect Oregon to prevail almost immediately. It is just crystal clear. National Guard troops can be deployed, broadly speaking, in one of two ways. They can be federalized under 10 U.S.C. Section 12406, put under the control of the federal government in those emergency situations, and then they are deployed within the state in which they have been federalized. That is Title 10 status. Ordinarily, National Guard units remain in what is called Title 32 status. That is 32 U.S.C. Section 502F. That means they can be paid and supported by the federal government, but the chain of command, they remain under the command of the state National Guard commanders and ultimately subject to the governor of their respective state as commander-in-chief. And the critical thing is there is both text of the statute and controlling case law that says National Guard units must be in Title 32 status to be deployed to a different state, and they must be deployed. They can only be deployed with the consent of the governor of that foreign state, right? And you can imagine why that would happen, right? Like during Hurricane Katrina, for example, you would send National Guard units from neighboring states into Louisiana to aid in the cleanup efforts. If the governor of Louisiana says, yes, we welcome the help, there is no precedent for and no legal allowance to deploy National Guard units from one state into another state without the second state's consent. The reason is because of their experience with the District of Columbia. Because Washington, D.C. is not a state, the law was unclear, and the Trump administration sent National Guard units from other states, from red states, into D.C. The law is very, very clear with respect to sending those units into a different state. And so I expect that Oregon will prevail. We'll get a TRO before this show goes to air.
Okay, so now let's talk about Chicago, which is also very much in flux. We're recording a day earlier than when we usually do, and that day is Monday, so God knows what's going to happen. As of now, there are these horrible ICE raids going on in Chicago. I'm sure you've seen all of this coverage, including that astonishingly illegal raid on an apartment building where ICE pulled out all of these people, including some of whom were clearly citizens, in the middle of the night, babies pulled out in their pajamas and zip tied together and put in trucks for hours and hours. The reporting there is that ICE agents divided the residents, that the Black residents, it's a mainly Black and Hispanic building. The Black residents were put in vans and locked up for hours, and the Hispanic residents were separated out and screened for their citizenship and for potential deportation. There was massive destruction. The building was basically trashed. Every unit had its doors broken down. There does not appear to have been a warrant for this kind of search. There may have been some kind of warrant to pick up non-citizens. But I think it's important to realize, I mean, we've talked about Kavanaugh stops, which a law professor named Emil Kahan coined the term because of Justice Kavanaugh on the shadow docket explaining why they allowed certain, this is within California. This is other litigation coming out of ICE's raids in California. And a judge there named Mami Frimpong issued an order that said ICE could not use race along with occupation, language people are speaking English with an accent, or where they were standing. Could not use those 4 factors alone or in combination to justify a search or a detentive stop that couldn't be probable cause. And the Supreme Court's conservatives said, yes, you could, although they said it quietly. They said it on the shadow docket. But Justice Kavanaugh, Leroy Jenkins, to his friends, said, oh, no, it's fine. Race is fine. Races are perfectly good. Let's do some racial profiling. And he talked about this as such a hail fellow well met. He characterized it basically as like the ICE agents say like, hey, are you a citizen? And you say, yes, sir, I am. And then everybody goes on their way. And greenlighting that, there is a straight line between Kavanaugh greenlighting those detentive stops that he imagined in his mind, even though we've all seen ICE agents tackling people with no probable cause other than you are brown and in public. There is a straight line between that and this thing that happened, the wholesale arrest and zip tying babies in the night. That's on Kavanaugh. That's on the court's 6 conservatives.
Indeed. I want to talk about 3 things with respect to Chicago. The first is the administration clearly trying to replay the Los Angeles playbook in terms of sending in ICE and having them be as disruptive as possible to provoke protests, hoping that those protests will turn violent, and then hoping that they can use that violent protest as the basis for asserting that they can't enforce the law under 12406. And I would add that puts the mayor of Chicago and Governor J.B. Pritzker of Illinois in a difficult spot, right? Like, I see folks on our side asking, why is the Chicago Police Department, right? Why are you helping ICE do these horrible things? And the answer is because you're in this impossible spot, right? Like, if the local police obstruct ICE and prevent them from doing their job, that too can become evidence that says, see, ICE can't get the job done. That's why there must be federal troops sent in to protect them. So it's this really difficult tightrope to walk to say, no, you don't need to invoke 12406. We are perfectly capable of enforcing our own laws. And I have to say, with respect to that, the way that Governor Pritzker has handled this publicly is, I think, a model for other governors that may have cities targeted by the Trump administration. He took to social media and said, this morning, the Trump administration's Department of War gave me an ultimatum. Call up your troops or we will. It is absolutely outrageous and un-American to demand that a governor send military troops within our own borders and against our will. Yesterday, Kristi Noem's masked agents threw chemical agents near an elementary school, arrested elected officials exercising their First Amendment rights, and raided a Walmart. Walmart. State, county, and local law enforcement have been working together and coordinating to ensure public safety around the Broadview ICE facility and to protect people's ability to peacefully exercise their constitutional rights. And then he went on to have a call for no violence. And I just can't echo that strongly enough, right? If people protesting are violent, that will be cited by the administration as a justification to escalate the violence. So I know it's provocative. I know it's not fair. I know it's hard to have to play by the Marquis of Queensberry rules when the administration is being illegal, but that is the strategy for prevailing in court and keeping the troops out. What do you think, Liz?
Yeah, I'm not totally sure that I agree with all of that. I think it's really hard to ask people who are under attack, who are literally under attack. I do not think that if someone came for my child or my mother, I would be able to obey the law. And so it's a difficult situation. It's absolutely. I agree with you that that's what's happening here, that the Trump administration is trying very hard to provoke something that they can point to as violence and as justification to deploy the National Guard. I'm not really sure what they think they're going to get out of it. Some people have suggested that deploying the Guard is itself, a step, an intermediate step to get people used to soldiers in the streets so that, we can be one step closer to military rule. I mean, I can't read the mind of these horrible thugs. I like, why do they do the cruel, horrible things that they do? I mean, yes, racism, but I'm not really sure.
Yeah, you were reminding me of the order from Judge Young in Massachusetts that we talked about on our last episode, right? And one of the things he said that struck me was, he said, the Trump administration has successfully convinced a large segment of the population that ICE is responsible for law enforcement when it is not responsible for law enforcement. So I think you're on to something with respect to changing public perception and making it seem normal that, this is just what presidents do. They send masked armed troops into cities on a whim. And I wouldn't think it could happen here, but I wouldn't have thought, most of 2025 could happen here.
All right. That is gloomy as hell, but we do have a little fun and frivolity for you to as a reward for sticking around. If you wait for us after the ad break, we got Alex Jones getting what's coming. We'll talk to you in a sec. Okay, on last Tuesday's episode, we told you there was drama in the Alex Jones bankruptcy and an emergency hearing scheduled for Wednesday. We listened in on that hearing, and it did not disappoint. I know we've said this before, but it looks like Alex Jones is finally running out of road in his effort to use bankruptcy to fend off the Sandy Hook parents. He and his company, Free Speech Systems, owe them over $1 billion, and that debt is non-dischargeable in bankruptcy because it is the result of a willful tort. That tort's defamation. So far, the Sandy Hook families have not seen $1 from Jones, but I think that is finally about to change. So, okay. Remember, Alex Jones runs his show InfoWars through FSS, Free Speech Systems, of which he is the sole owner. There have been several bankruptcy filings. The only one that's still a live concern is Jones's personal bankruptcy under Chapter 7, which is liquidation. That's where the court sells off all your assets and splits up the proceeds among your creditors. FSS was in bankruptcy, but that case got dismissed last fall. When the case got dismissed, the Texas plaintiffs, because remember there's two sets, Texas and Connecticut in the Sandy Hook plaintiffs, the Texas plaintiffs went to a state court and tried to seize FSS's assets. That's the IP, customer lists, recording studio, the buildings, whatever.
Right.
At that point, bankruptcy judge Christopher Lopez said, no, we're going to deem that stuff an asset of Alex Jones's bankruptcy estate and auction it off. So he issued a supplemental order blocking the seizure of those assets in state court. So the Texas plaintiffs who had gone to court and said, give us FSS, were not allowed to seize it.
Right. That auction, as we covered at some length, did not go well.
No.
And when it fell through, Judge Lopez essentially threw up his hands and said, fine, we're done here. I tried to get these assets handled in bankruptcy where similarly situated creditors would be treated similarly. But no, I was trying to head off a race into state court where whoever gets there first gets it all. But you guys wouldn't cooperate. So fine, have at it. Have a race to the courthouse, which the Sandy Hook families then went out and did. As far as we can tell, they got on the same page, cooperated, went into the Texas courts and said, okay, these assets are no longer being auctioned off. Give it to us. We're going to attach them to satisfy our judgments. But Alex Jones's lawyers have been opposing those attachment orders by waving around that supplemental order from Judge Lopez from before the auction and telling state courts, no, see, free speech systems is a part of the bankruptcy. And therefore, if it were, it would be subject to what we've talked about before, the automatic stay. So the argument was you cannot execute that seizure of those assets.
That would seem to me to be a lie. Judge Lopez did not call it a lie, although he did say to Jones's lawyers, you just don't understand bankruptcy law.
Yeah, there's a fine line between making a clever argument and being stupid, right? But here's the thing. That old supplemental order was a written document issued in a bankruptcy court, signed by the judge, stamped and everything. So you can hand it to a bank and it looks official. Now, that order got rescinded, but Judge Lopez rescinded it orally in several different hearings. But the Sandy Hook families had to rebut that introduction by offering up transcripts of those oral readings. And look, from a practitioner standpoint, I get why local courts and why banks and other places of, they don't want to touch this. They're not going to second guess. The easiest thing to do is to say, look, I don't know who's right here. I'm just going to err on the side of caution and not turn over something where a bankruptcy court could later come and could get me into trouble.
Right. So the Sandy Hook families filed an emergency motion to confirm that the assets of FSS are not property of the Alex Jones bankruptcy and can be seized in state court. And if they got such an order, that would give them their own kind of written signed document that was stamped today, which they could hand to the state judge and say, give us FSS. And that's what they got. Judge Lopez gave them an order, which they can now take back to court and get the FSS assets.
And to avoid future confusion, if there was confusion, and frankly, I do not think that it was. I don't think Judge Lopez thinks that it was. But he also ordered the trustee, Christopher Murray, to dispose of the equity of free speech systems, right? That is Alex Jones's 100% ownership of that LLC. It's the equivalent of having a stock certificate. It's called a membership interest. Because the slippage here seems to be the difference between FSS, the LLC, and the assets that the business owns. Because remember, Free Speech Systems itself was also a defendant in those Sandy Hook defamation lawsuits. It is therefore jointly and severally liable for that $1 billion+ of judgments, right? And jointly and severally means that the plaintiffs can choose who to go after. They can go after the FSS assets to satisfy that judgment. And because, as you said, Liz, that debt was non-dischargeable, it survived the FSS bankruptcy that got dismissed. So what that means is that no one in their right mind would buy FSS, the company, right? They'd be buying assets encumbered by $1 billion worth of liabilities. And so, look, I don't know what the InfoWars IP is worth, but it is a whole lot less than $1 billion.
Right.
So what the trustee, Chris Murray, did was file a notice of proposed abandonment. That is pursuant to 11 USC section 554. Now, that provision of the bankruptcy code is typically used for things like when an estate contains swampland property that's been condemned. And what the debtor does in declaring bankruptcy is give all of the assets over to the estate and let the trustee manage it. But the trustee looks at it and says, oh, this is worthless. I don't want to administer it. Get it out of here.
Right. So the language of the statute says that after notice and a hearing, the trustee may abandon any property that is burdensome to the estate or that is of inconsequential value and benefit to the estate. So by abandoning it, now nobody owns Free Speech Systems. FSS owns a bunch of assets, though, and all of those can be seized by its creditors, including using the ordinary attachment process in state court. So, long story short, I think this week, the Sandy Hook parents will be able to go into Texas state court and take FSS, take InfoWars, take all of those assets and deprive Alex Jones of the benefit of his hate megaphone, which is used to harm them, to harm society, to harm all of us for so many years.
Yeah. And one more wrinkle. I have no knowledge if this will happen, but if the InfoWars intellectual property winds up in the hands of the Sandy Hook plaintiffs, that might revive that deal that got rejected during the auction, right? Where the satirical website, The Onion, would run the InfoWars website, which, look, Liz, we need some good news in 2025.
Oh, we absolutely do. But look, irrespective of whether The Onion comes back in, because that was absolutely perfect, and I also would love for that to happen. But shutting this thing down, that's important, right? Look, obviously, Alex Jones is going to go somewhere else. He's going to go do some other thing that will be destructive to society. But ending InfoWars, that matters.
Hear, hear.
Okay, that is going to do it for us today. Unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case we have a fun little segment on the National Review and U.S. Attorney for the Eastern District of Virginia, Lindsey Halligan, although maybe not, question mark, and Sam Alito, but in a good way. Also a question mark. All right. If not, we will talk to you guys on Friday. We have a fun interview, and we will be back as usual on Thursday with written content. Thanks, guys.
Law and Chaos Podcast is a production of Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Ipsa Media, LLC, all rights reserved.
Shopify's point-of-sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/listen. Shopify.com/listen.